Hello, everyone, and thank you for being with us today. Apologies for the little bit of a late start, but nonetheless, we have plenty of time to get into some great details for today's webinar. So hopefully for many of you, you've already had a chance to familiarize yourself with the vLex Fastcase platform, and you're here because you want to learn how to take your platform to the next level. If so, you're in the right place. But to provide a bit of a background on vLex and Fastcase and where we are today, I'd like to highlight our mission, which is to continue to democratize the law so that it's accessible to everyone. But we also have an aim to revolutionize how attorneys engage with legal information. Technology is advancing faster than ever, and AI is at the forefront of that transformation. While we still preserve the traditional research platform included in your bar plans that a lot of you are familiar with, traditional methods of gathering information, analyzing data, and making decisions is being replaced by AI-driven solutions that are, a little bit quicker, more efficient, sometimes smarter, not always. But to stay ahead, adopting these tools isn't really an option anymore. It's almost a necessity. So the tool and content that we're going to explore today focuses on the revolution of legal research methods aspect of our mission, and we're excited to show you these tools in action. But before we introduce you to Vincent, let's go ahead and introduce you to our speakers for today's presentation, starting with myself. My name is TJ. I am a customer success representative with vLex, and very exciting times in general for our company. Enjoy coming to work every day and working for a very smart team and continuing to provide additional methods and solutions to you as bar members across the US. But today I have the pleasure of being joined by Damien. And Damien, go ahead and introduce yourself, sir.
Hi, Damien Reel. I've been a lawyer since 2002, coder since 1985. So I've litigated for about 15 years, and I spend part of my day coding, part of my day building and talking about the stuff I've been building, and I'm going to do that in the second half of this discussion. So really thrilled to be here.
Yes, and we're thrilled to have Damien. He's a very busy guy, so to have any bit of his time is very valuable. So we should feel blessed.
That's
But
nice
before we
to say.
get it, yeah. But before we get into too much detail, I wanted to start with our agenda here. So we'll begin with introductions, as we already have. But I am going to cover your bar plans as well, so you know exactly what you have access to already. But then what you also can upgrade your account level to as well. And then I will pass to Damien. He'll cover Vincent AI in thorough detail with some workflows and examples. And then we'll take a step back and how you can access the next steps, starting trials, getting in touch with us for demos. And at the very end, we'll save hopefully 5 to 10 minutes or so for some questions as well. But with that, let's go ahead and take a look at what our bar plans are. So not all bar partners are the same, depending on what bar association you're connected with. It may be one of these 3 different plans. We have the state core, which is all of the primary state materials, so your cases, statutes, regulations, constitutions, etc., and then some related federal content as well. And I'll get into the platform itself and show you exactly where you can see what your bar plan is. But for now, I'm just going to cover these different plans in detail. So if you have the state core, it would say, for example, Florida core would be a state core plan. So, and then if you have the next level up, would be US core plan, which just captures all 50 states' primary materials as well as all federal content, and that's primary content. So again, any cases, statutes, regulations, etc. And that would say vLex Fastcase United States core rather than state core. And then lastly, and the US Core Plus plan, this captures our docket alarm content. So not only do you have access to all 50 states and federal primary materials, you also have access to millions of documents like briefs, pleadings, motions, and orders content from across state and federal trial courts. And we're constantly adding thousands of documents a day to this to our docket alarm content. Now let's go ahead and look at where the bar plan is in the actual platform. So I'm just going to navigate over to a test account here. I am located in the state of Georgia, so I've pulled up the State Bar of Georgia account. And you'll notice down on the bottom left-hand corner of your account, you're going to see the State Bar name or logo here. And then just underneath that, you have the vLex Fastcase United States, or excuse me, you have your plan level, which in this case is the US Core Plus, which it includes the docket alarm essential content. And before I pass over to Damien, I did want to highlight where you actually already have access to some of Vincent's powers. So with your, no matter what bar plan you have, if we were in a case level, so I'm just going to access a recent case here that I was looking at, you have a few instances of how Vincent is already included in your member benefit. Now, in the case level here, we can see there's a case analysis that's been populated. This is powered by Vincent AI, so it gives you it gives you the legal issue that's being discussed in this case, some head notes, and even key paragraphs and phrases. And this is a great resource to quickly find more information about this this case. Now, this will be present on any case you navigate to. It'll summarize the content within this document and provide the case analysis up here at the top. Now, one other way you have access to, that Vincent AI is incorporated into your bar plan is through the Related tab. So again, we are using the powers of the Vincent AI program to provide you with some related content that may be similar to the case that you're already on. So it's going to take some of those key topics and categories. All right, so let me go ahead and get Damien set up with some sharing responsibilities here now that we've seen where you can go to access Vincent AI in the platform that's part of your member benefits. And Damien, you should have sharing access now, sir.
Sounds great. And it looks like I now have the wrong screen being shared. Let's see if I can share the correct screen. How does one correct? So here is, we are using GoToWebinar, which is often a very good one, but let's see. It doesn't allow me to select my multiple monitors. It just selects the monitor that it wants to select, which is not the right one. All right, so now if I right click, there we go. All right, 1 second. Oh man, I'm gonna have a strongly worded letter to GoToWebinar. All right, so now you should be able to see what would you like to do. So Vincent AI is collecting workflows. A workflow is something that a lawyer does, whether that being asking a research question or being able to build an argument that supports your facts and law. I want to be able to analyze a contract that is merely upload a PDF and no prompting necessary, get over 100 pages worth of analysis of that contract. Or do the same thing for a complaint. Upload a complaint and get over 200 pages worth of analysis of that complaint. And then you can condense those 200 pages into a 1-paragraph memo or an email to your client. What if you want to do a 50-state survey in one fell swoop? Do the same thing for multiple countries if your client does work in the European Union or in Mexico. What if you want to be able to see this version 2 of the contract? How does it differ from version 1 of the contract? And how do I be able to change my negotiation strategy? What if I want to be able to support or oppose propositions? Each one of these things is a workflow, and we're going to go through several of these workflows. The first workflow is asking a research question right here. You could try to ask a research question of ChatGPT, but that's a bad idea. I asked Steve Schwartz why it's a bad idea, and he'll tell you that it might hallucinate cases. And even if it doesn't hallucinate cases, you can see here it's provided the Defend Trade Secret Act, but it's not giving me any particular language from the statute. It's not giving me any subsections of the statute. So if I need to do the legal research anyway, what's the point of doing it in ChatGPT? So what if you were to instead ask the same legal research question and about privacy laws related to online advertising, or the same legal research question about trade secret law regarding former employees stealing customer lists, and you were to run it across actual California cases, statutes, and regulations. So right now you can see what is the trade secret law regarding former employees stealing customer lists, and it's running it across California cases, non-hallucinated, non-hallucinated California statutes and regulations, non-hallucinated administrative decisions, and secondary materials like those from the American Bar Association and from various other sources. So now you can see here it's already found 52 authorities, cases, statutes, and regulations. And then it's done a 5-stage review of those. Stage 1 of that 5-stage review is to find actual non-hallucinated text from actual non-hallucinated cases. This text that you see here and the text that you see here, this will be non-hallucinated now 100% of the time, not 90%, not 99%, but literally 100% of the time, this text will be non-hallucinated, and 100% of the time, this case will be non-hallucinated. And you might say, Damien, how can you say 100%? And I can say 100% is because this was not created by a large language model. This is a database search, like we've been doing database searches for the last 40 years. So 100% of the time, this text will be non-hallucinated, and 100% of the time, this case will be non-hallucinated. So we provide you with the ground truth non-hallucinated text. That's stage 1. Then stage 2 is we say to the large language model, tell me how well this text answers the user's question. And here's how well or how poorly American Paper answers the question. Here's how well or how poorly GI Services answers the question. So we provide you individualized analyses for every single case, statute, and regulation. That's stage 2. Then stage 3 is we say to the large language model, now that you've done this analysis, assign a number as to how well American Paper does. So you can see American Paper mostly answers the question, GI Services mostly answers the question, whereas Courtesy Temporary Services totally answers the question. So these confidence scores, you'll see confidence scores of 100, you'll see confidence scores of 90, 80, 70, but you won't see anything below 70, because if it's below 70, we throw it away. So all you see here are 27 cases that are above that 70% threshold. That's stage 3. Then stage 4 is we say, well, if any of these particular cases answers the question, then maybe the cases that it cites might also answer the question. So we go to, for example, American Paper, and we go into American Paper, and we say, well, if much like a good researcher would say, well, if American Paper answers the question, maybe the cases that American Paper cites might also answer the question. So we do that same stage 1, stage 2, stage 3 process on all 6 of these cases. And if any of these cases are above that 70% threshold, we add that to the list. So we call this going down the tree. We also go up the tree. Many cases cite American Paper. Jan Marini cites American Paper, so does ABBA Rubber. So we do that same stage 1, stage 2, stage 3 process on all 44 of the cases that cite American Paper. And if any of those 44 are above that 70% threshold, we add that to the list too. We call this going up the tree. I've spoken at over 100 conferences in 2024. So many people say on stage, I don't know when ChatGPT is going to reach human levels of analysis. I litigated for about 15 years for Robbins Kaplan. I know 0 humans when they find a case like American Paper. I know 0 humans that are going to read through all 6 cases that American Paper cites, as well as I know 0 humans that are going to read through all 44 cases that cite American Paper. Vincent does both of those things in about 1.5 minutes. And it does that not just for American Paper, it also does that for GI Services. It also does that for Courtesy. So we do that same down the tree and up the tree for all 27 of these cases. And if any of those hundreds of cases are above that 70% threshold, we add that to the tree. So we're doing superhuman work at superhuman speed. That's stage 4. Then stage 5 is to take all 58 of these cases, statutes and regulations, and secondary materials and turn them into a memo, much like an associate would. And when I was a Robbins Kaplan, I would tell my associates, don't make me wait till the bottom to give me the answer. Give me the answer right up top. So we prompt it. We prompt Vincent to say, for all 58 of these, answer the user's question in 1 paragraph. And it'll do that 100% of the time. Then I would tell my associates, dig deeper into the most relevant statutes. And here are the most relevant statutes. I would tell my associates, dig deeper into the most relevant cases. And these are the most relevant cases. Then large language models are sycophants. They tell you what you want to hear. So we counteract that by prompting, by saying, don't tell me just what I want to hear, tell me what I need to hear. Give me the exceptions to the rule. Give me the flies in my ointment. So here you can see Vincent said, well, if the information is readily ascertainable through public sources, then it's probably not a trade secret. This is a fly in the ointment that a large language model is not going to give you out of the box. It only gives you these exceptions because we've asked it to. So If you think about how long it would take a human associate to read through hundreds of cases, land on the 27 that are above that 70% threshold, and then turn everything into a memorandum that you see here, probably going to take longer than a minute and a half to do that. Then it's going to take that human longer than the minute and a half than it took Vincent to do here. Now I can copy this and paste it into an email, or copy any of these particular provisions, or download it as a PDF, or download it as a Microsoft Word document, as I'm doing right now. And then you're going to see this Microsoft Word document that I can then paste into maybe my brief, pleading, motion, etc. And ironically, it's often takes longer for the Microsoft Word to open up than it does to be able to build the Vincent memo in the first place. But let's see how long it takes Microsoft Word to start up. And you'll see essentially what's replicated on this screen in Microsoft Word. Here's the question that I asked. Here's the memorandum on the left-hand side. And then here are the cases, statutes, and regulations, all the legal authorities on the right-hand side. And so here, if I scroll to the bottom, you can see that this is a 33-page memorandum done in about a minute and a half. Of course, this is not the end, but it is a really good head start, where now I could be able to go into and read Altavion and read Stelling Services. And I could either do that in the Microsoft Word document or do that here. So I can go into GI Services and be able to read this case, statute, and regulation to ensure that it actually is being able to do this work for me in my case. So this is workflow number one, asking a legal research question. But sometimes I don't want an objective answer to this research question. I'm a litigator, I like to argue. So I either support my arguments or I oppose the other side's arguments. So if the other side has argued that a recording of a conversation without consent violates privacy laws, what if I want to be able to find the other side of that argument? And so here it's going to start this, and I'm going to pull the old baking show trick of being able to show you something I've already baked. So now it said, hey, listen, you didn't have a reasonable expectation of privacy, or this is a Zoom call, or you live in a one-party consent state, or you impliedly consented when you heard the beep, or I'm a reporter, and this is in the public interest. These are all good counter arguments that are opposed to this proposition. And so what Vincent has done is found cases, statutes and regulations, and secondary materials that are on the other side of this argument. And now here is a good response. And this is not an objective analysis like you would in a bench memo, but this is actually a subjective argumentative that you can put into a brief, pleading, motion, or a letter to the other side. So this is either supporting or opposing the other side's legal propositions. That's workflow number two. Workflow number three is what if you want to go full on argument? And of course, most of the arguments you're making apply your client's facts to the law. And so what I've done here is I've copied and pasted and written in my facts. Here I represent Sarah Johnson. And Sarah disclosed sensitive personal details to Michael, who put his smartphone on the table and then activated his recording function without Sarah's knowledge. So I've entered my client's facts here, and then I've entered my goals. What do I want out of this? I want to be able to show that defendant's recording of the conversation without consent violates privacy laws. So what Vincent does is it finds cases, statutes and regulations, and secondary materials that support this argument. Here's an introduction of that argument. Here are the most relevant facts of the ones that I provided. Here are the legal principles, including federal statutes and state statutes and state causes of action with actual non-hallucinated cases that are here. Then everything a lawyer does is applying law to facts, or if you prefer, applying facts to law. So here you can see, given that the defendant recorded the conversation without the plaintiff's consent and under the principle of this federal statute, it's likely the defendant's actions constituted a violation of privacy laws because the plaintiff had a reasonable expectation of privacy as reflected by the principles in Katz versus United States and Jones. And it further is prohibited under SEPA, the state law statute, as interpreted by these cases. Here are the most relevant submissions under each of the statutes. Here are arguments in the alternative. Here are areas of risk. You can see here that the argument is weakened by the fact that Katz and Jones have been superseded by statute. So here you can see that as cases come in, we actually flag them as being superseded by statute. So you can see here that US versus Jones was superseded by statute as recognized by Whittington in 2021. So when Whittington comes in, we actually flag this as being superseded by statute, or we flag this case as being distinguished by Cockrum. So we take these analyses as provided by our citator, which is one of the leading citators in the world, and we put these analyses into the large language model's output. So we say to the large language model, Vincent, we say, take into account the fact that things are superseded by statute. So you might want to say, yes, Roe v. Wade was the law of the land for 30 years, but also said that it was overturned or overruled by Dobbs. So this is a way that we essentially do things that ChatGPT out of the box is not going to do, and do things that our other competitors do not do either. So this is workflow number 3, building an argument, where you take your particular facts from your case, say your goals, and then Vincent will find cases, statutes, and regulations, and provide an application of the law to facts or facts to law to support your argument. So this is workflow number 3. Workflow number 4 is, what if you could do an entire 50-state survey in minutes? So here, Vincent, we've asked, tell me about the right to work laws and how they affect union membership and dues. Vincent is smart enough to take a multiple question and split it into its component parts. Vincent says, oh, that's actually 2 questions. Question number 1 is the right to work laws. Question number 2 is how it affects union membership and dues. And you can see here that Vincent provided 100 memoranda, 50 for question number 1 plus 50 for question number 2 equals 100 memoranda for Alabama, Alaska, Arizona, Arkansas. And then if I scroll down to Texas, here is now Texas. Here is the 1-paragraph summary of all the Texas law. Then I can click to be able to say, here are the Texas cases, statutes, and regulations. And then here is the full memo for Texas. The short response for Texas, the 1 paragraph, the most relevant statutes, the most relevant cases, the most relevant secondary materials, and then again, the flies in my ointment. And we do that not just for Texas, but for all 50 states. And we do that in about 5 minutes. Then beyond that, we say, okay, now we put everything to a table. We say, Vincent, give me a table of right to work law. Yes, no, yes, no. And here's the statutes, here are the most relevant cases, and here are the exceptions and limitations. We do that 50-state survey in one fell swoop that I can now download this as an Excel spreadsheet or a CSV file. Then we do the same thing for question number 2. How do they affect union membership and dues? Vincent, we ask it to create new columns on the fly. So this new column is union membership voluntary? Are dues payments voluntary? Vincent came up with these things on the fly, and then we fill in the blanks. Yes, no, and we provide the most relevant cases and whether dues payments are voluntary. Then you could be able to take this and be able to do things with it, like say, now draft a contract provision that provides a good result for avoiding those right to work laws in both Alabama and in Texas. And now here's a contract provision that uses all 100 memoranda to be able to then draft this. And then here's another one saying draft a contract provision incorporating the provisions and learnings from all 50 states. And now here is essentially the 50-state survey, at least a good first draft to be able to avoid right to work laws in all 50 states. This is a way that you could be able to jumpstart your legal research. And if you've ever built a 50-state survey, you know 2 things, and I've built a lot of them. First thing is they take forever. They take weeks or months to do a good 50-state survey. Thing number 2 is that survey is obsolete as soon as the ink is dry, because tomorrow there's going to be a new case. There's going to be a new statute. There's going to be new regulation. So you have to go through the pain of thing 1 all over again. We take care of both of these pain points. This 50-state survey is not going to take weeks or months. It literally takes minutes, usually 5. So and because it only takes 5 minutes, you could run it again tomorrow or next week or next quarter, whenever you'd like. So of course, for the law firms that charge their clients flat fees for 50-state surveys, they love this. They say, this is amazing. We can shrink our cost to increase our profit margin. So law firms that charge flat fees love this. You know who also loves this are the Fortune 100 and Fortune 50 corporations that we sell to. Because those clients say, wait, why would I even hire a law firm to do this? Why wouldn't we just do this ourselves in-house? So for the law firms that get it, that realize that we're in a different world than we were in 2021 before ChatGPT and before Vincent, they're going to make a lot of money where they're going to be able to sell 50-state surveys for a lot cheaper, and they'll have a runway of maybe a few months, a few years before the clients figure out they can do it themselves. But during that runway, the law firms that get it are going to be able to make a lot of money. So this is a 50-state survey. What if we could do the same thing with the multiple country survey? Your clients don't just work in the United States. They also want to know about privacy laws related to online advertising in places where they do business, like the United Kingdom, Ireland, France, Spain, Portugal, Italy, the European Union writ large, Mexico, Brazil, Colombia, Chile, Hong Kong, Singapore. So here, Vincent has not just done a 50-state survey, but a multiple country survey. So we've answered the question about privacy laws and online ads in the UK and Ireland, France, Spain. You can see here that we do a neat trick where we give you the answer to Spanish law, and we've done that by running it across Spanish legal texts and then round tripping it back into English. So to be clear, we do that in Spain. We also do that in Mexico. So here is Mexican Spanish, and then here's the answer in English. So to be clear, I've asked an English question, run across Spanish law, and then round tripped it back into English. As far as I know, we're the only game in town that does this kind of round tripping. And then, much like the 50-state survey, we provide a table at the bottom to be able to say, what are the privacy laws? What is the key legislation for each of the GDPR related things? Does it require user consent? What is the data protection authority? These are all columns that Vincent came up with on the fly. And we do that for multiple questions that could be done. To be able to do the magic that I just showed you requires the data. That is, only 3 companies in the world have comprehensive cases, statutes, and regulations, including the case that was decided yesterday, or the regulation that was decided yesterday. Those comprehensive sources are Thomson Reuters, where I used to work, LexisNexis, and us at vLex. And you might say, wait, Casetext Co-Counsel, before they were acquired by Thomson Reuters, where did Casetext get their data? And the answer is from these guys. Every day we would give Jake and Pablo our cases, our statutes, and our regulations. But what they didn't have, Jake and Pablo didn't have continental European cases from Spain, Italy, France, or the European Union. They also didn't have UK data, such as cases and legislation back to the year 1235. We've been collecting UK data since 1985. They also didn't have any information from the tax havens of Jamaica, the Bahamas, or the Cayman Islands. They also didn't have anything from the banking powerhouses of Hong Kong, Malaysia, or Singapore. So if you think about, only 3 companies in the world have comprehensive cases, statutes, and regulations for the US. But if you go worldwide with the depth and breadth of vLex, there's only one game in town that allows you to do this kind of multi-country jurisdictional survey, asking a question in your native tongue, running it across Spanish language or other language texts, including Italian or Portuguese or French, and then be able to round trip it from French back into English. Only one game in town that allows this. So now, what if you want to be able to do that, not just comparing jurisdictions, but also be able to analyze a complaint, no prompting necessary? Steve Jobs was asked on, Steve Jobs said that the best user interface is no user interface. And I agree with Steve. And Sam Altman, who is the CEO of OpenAI, who makes ChatGPT, Sam Altman was asked on stage, what do you think of the ascendance of prompt engineering as a field? And Sam said, ugh, I hope that's not a thing in a year. Because if I'm doing my job correctly, you won't have to be a prompt engineer. All you have to do is ask me a question, and I'll give you an answer. I agree with both Sam and Steve that if we at vLex and Vincent are doing our jobs correctly, you won't have to be a prompt engineer. All you have to do is upload a PDF, like this New York Times versus Microsoft OpenAI complaint. Vincent will then recognize, oh, that's a complaint alleging copyright infringement. And based on that, Vincent will give you these buttons, no prompting necessary. And these buttons reflect what I, as a litigator at Robbins Kaplan, did for every single complaint I received. I would say, what are the claims being alleged? What are the facts supporting those claims? Who are the parties? What are they looking for? Are they looking for money, or are they looking for an injunction? These are all extractive tasks, and we do this no prompting necessary. Then beyond extraction, we go to ideation. What legal defenses can we mount for each claim? What questions should we ask our client to help them win? This is the work of the lawyer, and we do this no prompting necessary. We also give you these legal research questions in purple, and it's customized based on this complaint. Because it's a copyright case, we say you might want to know about statutory and actual damages for copyright cases. You might want to know about fair use. You might want to know about transformative use. Vincent came up with these 3 questions on the fly based on this, no prompting necessary. So as a user, to be able to say, here are all the claims, and here's an analysis of each of the claims. Here's the relevant statute. It's not state law, it's federal law. Here are the most relevant facts. Here are the parties for copyright infringement. And then we repeat that for every single claim in the complaint. That's stage 1. Then we go on to stage 2 as to say who did what when. We give you a nice timeline of who did what when. We've done that here for 1 document. We could have just as well done it for 5 or 10 or 20 or 50 or 100 or soon 10,000. Then I want to be able to say for each of these claims, what are good defenses to those claims? Well, for copyright infringement, maybe you want to argue fair use. This is what fair use is. You could say the use of the New York Times content by OpenAI was to train the models, and that's fundamentally different than the original publication. And AI-driven insights don't replicate the original journalistic function. These are all good arguments, and we provide those good arguments for every single claim in this complaint. That is, we provide good defenses and good legal arguments that are customized for this particular complaint. Then we say, okay, what questions should I ask my client to help them win? Here I represent OpenAI. So you could say, hey, OpenAI, what was your training data? What were your sources? Did you get permission from the New York Times? These are all good questions for every single claim in the complaint. Then beyond that, when I was at Robbins Kaplan, I would go to our document management system, iManage or NetDocuments. And I would say, I want to find cases like mine so I don't have to recreate the wheel. Vincent and Docket Alarm is better than any firm's document management system. Vincent has 875 million dockets and documents across all the federal courts and 38 state courts. So what you see here are 5 cases, each of which is a large language model copyright cases, a case like mine. These are all cases like mine. So I can go into any one of these, daily news, and I can click on daily news. And based on that, you can see that this is a Southern District of New York case that is a copyright case. And we've extracted everything that matters from this case. We've extracted every complaint and every answer in green. We've extracted every motion in blue. We've extracted every order in orange. And we've extracted whether that order has been granted or denied or partially granted, partially denied. Our competitors do that for 5 or 10 different motion types. We do that for over 200 motion types. So if my client asked me, what are the odds of winning this motion to seal? I would say in all the courts, it's 90%. But in this court, it is a bit different. In this court, the odds change a bit. For this judge, it changes a bit more. And for copyright cases, it changes a bit more. It's about 90%. So here are particular ways that the odds change depending on how this judge rules versus how the Southern District. And if I want to do a motion to seal, and I want the judge to grant my motion to seal in the Southern District of New York, now I could be able to run a search. And I could be able to run a search not just for successful motions to seal in the Southern District, I could actually do successful motions to seal in front of Judge Stein. So now I could be able to say, Your Honor, this is just like the case you decided yesterday. Or Your Honor, this is just like the case you decided a few days ago. This is now a universal document management system filled with all of the complaints, answers, motions, orders, not just for your law firm, but for all the most, I guess, the most prestigious law firms in the world. Here are all these cases like mine, and then we do the analysis of those cases. So here's the daily news. We say, here are the claims for the daily news. Here are the facts supporting those claims. Here's how daily news is similar to the New York Times case. Same jurisdiction, same defendants. Here's how daily news is different. Than the New York Times, different plaintiffs, different copyrighted works. And we do that individualized analysis, 5 cases like. And then who are the parties? Well, here's the New York Times, here's Microsoft, here's all the OpenAI entities, including wholly owned subsidiaries and holding companies. Now you can be able to say, what are they looking for? They're looking for money, they're looking for an injunction, they're looking to destroy ChatGPT altogether. Then beyond that, what if I want to move to a different venue that's more favorable to my client? Here's the analysis for subject matter, personal jurisdiction, and the analysis for venue. What are the legal bases for all my claims? What are the, if you want to prompt, you can. This is me prompting my motion to dismiss on the idea expression dichotomy. Here are non-hallucinated statutes and non-hallucinated cases that help me win. Here is my other prompt to say, listen, you essentially hacked the system by uploading the first 8 paragraphs of the article. And here's why we win under the Sony Betamax case from the 1980s. Here's a deposition outline for Sam Altman. Hey, Sam, how do you collect and curate your data? What are your sources? We could do the same deposition outline for Satya Nadella. Hey, Satya Nadella, what's the nature of your partnership with OpenAI? Why are you investing in OpenAI? These are all good questions for every single claim. Now, if you think about how long would it take a human associate to do all this work? I would say at Robbins Kaplan, this might take 200 plus hours of associate time. So of course, plaintiffs' lawyers, you can imagine, love this. Defense lawyers that bill by the hour love this a bit less for the reasons you can understand. But who really loves this are the Fortune 100 and Fortune 50 customers that use this. They say this is amazing. We're going to do 2 things. First thing we're going to do is we're going to take complaints we received over the last year. We're going to run them through this. And then we're going to say, what did the lawyers we hire add on top of those 200 pages, if anything? If the answer is nothing, that's going to say something. Then they're going to say, what did these 200 pages have as insights that we wish our lawyers had told us? And if the answer is a lot, that's going to say something too. So that's going backward. And then going forward, they say what they're going to do is for new complaints they receive, before they send those to their external lawyers, they're going to run those complaints through this. And then they're going to give the external lawyers these 200 pages. And they're going to say, what can you do on top of this? Because that's all we're going to pay you for. We're not going to pay you to recreate this 200-page wheel. So for the law firms that get it, this is not ChatGPT. This is a redefining of the client-lawyer relationship. Because the law firms that get it, they say, I can deliver way more value to my client in way less time, which is going to give me more work. You might know my friend Darth Vaughn from Ford Motor Company. He said, number one, you're going to use a large language model back tool, like you see here. And because you've now shrunk your cost to take these 200 hours and shrunk it, I'm going to give you way more work. So this is what's called Jevons paradox. If you shrink the cost, there's more demand. So that's thing number one for my friend Darth from Ford. Thing number two is my friend Leo Mergel from, he's the head of Salesforce legal operations. And Leo said, tools like Vincent, Vincent allows him to have much more sophisticated conversations with his clients much earlier. Because in the old world, you can imagine how long would it take a lawyer to do these 200 hours. In the old world, this might be 3 weeks or so to do this analysis. He said, now I get to have these sophisticated conversations on day one. It's not going to take me 3 weeks to get this. But on day one, I can say, what do you think of these defenses? What do you think about these questions that we should ask our client to be able to see what our posture is? I can have those really more sophisticated conversations on day one rather than waiting to week 3. So this is analyzing a complaint, a dramatic reshifting between client-lawyer relationship. But we don't just do that for complaints and litigation. We also do that for contracts. So here is a merger agreement that I've uploaded. Vincent says, oh, that's a merger agreement between Microsoft and LinkedIn. And based on that, we give you different buttons. Again, no prompting necessary. And these are buttons that contract lawyers care about. What are definitions? Give me overlapping clauses and ambiguities. How can I mitigate my risk? Give me language that's client hostile. Give me all my post-closing obligations across 300 pages. Tell me my fallback positions. What are key dates and deadlines that I need to follow? How should I comply with regulatory and procedural requirements? Again, we give you all of these, no prompting necessary. And then these legal research questions are, again, customized to this particular merger agreement. What are potential antitrust implications of the Microsoft-LinkedIn merger? What do LinkedIn's directors owe as fiduciary duties to their shareholders? These are, again, legal research questions, no prompting necessary. So here are the antitrust implications. In one paragraph, here's now the most relevant statutes and cases, secondary materials, and exceptions to the rule, the flies in the ointment. Then I want to be able to find all the defined terms. Here's a nice table of all the defined terms, and anywhere in Vincent you see a table, you can download that table as an Excel spreadsheet. Then tell me about the inconsistencies and overlaps. Maybe you want to look at 8.1e versus 8.1g. Here's why it's an issue, and here's maybe suggested revision of them. And then beyond that, you could be able to say, okay, what is client hostile language? I've told it that I represent LinkedIn. So here are client hostile language for imbalanced obligations and for excessive penalties and for restrictive covenants. So we provide this nice listing of the issue, why it's an issue, and suggestions to change those issues. Then beyond that, we could say, okay, give me follow-up questions. Give me a comprehensive risk analysis for my financial risks and operational risks and compliance risks and IP risks, patent and copyright risks. I could keep going, but we have over 100 pages worth of good analyses. Again, no prompting necessary to be able to go through this, to be able to do compliance checklists and other items. So this is analyzing contract, no prompting necessary. What if you could be able to say, give me version 1 of the contract, and how does that differ from version 2? Whether that contract is a settlement agreement in litigation, or whether that contract is another contract just out of the box. So here is a vendor agreement. Here's a summary of what's changed. Here's how it changes the allocation of risk. Here are the particular provisions that it's changed. And here's a table of what's changed, who it affects, what a description of that is, and whether it's high or medium or low risk in severity. Then here's another, to be able to say, here's the key findings. Here's a model vendor license agreement. Here's a summary of what's changed. So now I could be able to do a nice red line of what's changed in this new version. What if you want to take a deposition? And again, no prompting necessary, be able to do a good analysis of that deposition. Here we took a random deposition. And what we did, it tells us a nice timeline of all the things that were discussed in that deposition. Who did what when. Then here's who participated and the key themes of the deposition. His expertise and success in real estate, visibility of the board, etc. Then here's a narrative description of what happened in the deposition. And then for each of these, you could be able to have things you can put into a brief, pleading, or motion. Here's the text that is a summary. Here's a question from the lawyer. Here's a response from the deponent. Here are page and line numbers that you can put into the brief. And then here's the source. All of this is grounded in truth. So you can open up the PDF and we'll show you the particular portions of the PDF that are relied upon to be able to get the answer that you can see here. So we provide that in nice columns, and then you could be able to do things like be able to say, now put them into different causes of action, and to be able to split them in a way I can put into a brief, pleading, or motion. Now I can be able to very quickly do a deposition analysis. So that is a deposition analysis. What if you wanted to do docket research? And I'm going to ask you this question, and you tell me how you would find the answer to it. What's the average case length for civil rights cases that settle in the Central District of California? Today, how would you find the answer to this question if your client asks that? I would say I, as a litigator, would answer, I don't know, it really depends. Those are lawyers' favorite words, right? It depends. But you wouldn't be able to do what you see here, is where you could ask that plain language question, and we go through a bunch of California Central District Court cases. For each one of these, Glenn West, for example, this is a California Central District case that is a civil rights case. And we go through the date filed and the date terminated. And we use that data to go through and say that most cases settle within 2 years. So this gives you an answer to this question that previously was unanswerable, where you could be able to ask a plain language question. We run it across our structured data and give you a plain language answer to your plain language question. So that's docket research. What if you do the same thing for profiling a lawyer? Maybe opposing counsel is David Boies, and you want to know his experience in the Southern District. Here is David Boies' experience in the Southern District. For each of these cases, like American International, we say, what role did he play? What is the status of the case? What is the background of the case? What motions were brought? How long did the case last? What was the outcome? How complex was the case? Who were the experts? How much money was at stake? And we do that for every single case. And then we summarize this long line of David Boies cases into this memo that you see here. He does a lot of antitrust cases. Here are some of them. He does a lot of securities cases. Here are some of them. Now we have an individualized analysis of the profile of a particular lawyer. And then you could say, now go into detail on the antitrust cases, or go into detail on the securities cases. You could ask any follow-up questions. So that is profiling a lawyer. What if you could do the same thing for an entire law firm, perhaps opposing counsel? So tell me about Quinn Emanuel in the Central District. Here is the Central District, Quinn Emanuel cases, including role, status, background, etc. And it turns out they do a lot of product liability cases. IP cases, copyright, commercial litigation. Here's an analysis of this law firm. Again, ask a plain language question, run it across structured data, and then get a plain language answer. What if you want to do the same thing for a party? Maybe either your client or opposing counsel, the opposing party. Here are all the OpenAI cases and all the detail, and now here is the typical rule and effectiveness of those cases. What if you want to do the same thing for a judge? Susan Richard Nelson, right down the street. Now here are a bunch of Susan Richard Nelson cases. As turns out, she does a lot of risk cases for a Credit Reporting Act, civil rights cases. So do be able to profile what your judge's experience are in your particular areas of law. I was a judicial clerk, both for an Article III federal judge, as well as a state appellate judge. And for both of them, I would create bench memos. I would say, Your Honor, plaintiff says, defense says, judge, I think you should say. The problem is the plaintiff says it on page 1, and the defendant says it on page 20. So drafting a bench memo, connecting those dots would take me about 12 hours. So I thought maybe we can replicate this and have it take minutes. And that's what you see here. And I've uploaded all of the memoranda, the supporting memoranda and opposing memoranda. And this isn't just helpful for the judge or for the arbitrator. This is also helpful for the litigants themselves. Because once you upload this, Vincent splits it into legal issues and says, Your Honor, plaintiff argues, defense argues. Here's a summary of plaintiff's argument. Here's a verbatim excerpt of the plaintiff's argument, including particular sources of truth. That is, you can trust and verify the particular PDFs that are at issue here. So plaintiff argues, defense argues. Then here's legal issue number 2. Plaintiff argues, defense argues. Then we say, what are the weaknesses of each case? Plaintiff's weaknesses are the pre-existing hazardous condition and the plaintiff's knowledge. Defendant's weaknesses is that this is an open and obvious hazard and pre-existing conditions. So we give weaknesses for them. Then we have questions. What questions should we ask the defendant? What questions should we ask this defendant? How can you justify the claim that no duty was owed despite proving services on the property? These are all good questions. Here are facts asserted by a single party. Here are undisputed facts that I could use to be able to help this. So this is helpful, obviously, for judges and arbitrators, but this is also helpful for the litigants, because now the litigants can be able to see how the judge might perceive their weaknesses in the case. And litigants might be able to see what questions they might be asked at an oral argument to be able to then bolster their arguments. And the litigants might be able to say, maybe we want to dispute facts that maybe were previously undisputed. And we could be able to say, we can know what what the judge might say, okay, has either defendant known the standard for summary judgment? Is there genuine issue to a material fact? And here are genuine issues of material fact. Here are, now draft a judicial opinion denying summary judgment because there are genuine issues of material fact. And I, as a judge, could be able to have a first draft, again, based on actual non-hallucinated statutes and non-hallucinated cases, etc. So helpful, of course, for judges, also helpful for the litigants in front of judges. Everything I've just showed you is a workflow. Whether that workflows reflect what lawyers do, and we keep cranking these things out. I use my 15 years of litigation experience and our team that are also lawyers that have experience at contracts and in the litigation and all sorts of other areas. We keep thinking, what is it that we did as lawyers? And we crank those things out. Lawyers do research questions. We then don't just do objective answers, we want arguments. We want to be able to upload a contract and get 100 pages worth of analysis. Upload a complaint, get 100 pages worth of analysis. I want to do a 50-state survey or a multi-country survey in 5 minutes. I want to see version 1 of the contract and how it differs from version 2. I want to support my proposition or oppose the other side's proposition. I want to upload up to 10,000 documents and analyze those documents. So here, for example, I could be able to connect a collection. In this case, my collection is a copyright case of 954 cases, or due diligence, or a bunch of documents, any documents that I upload. And then once I connect it, I could be able to ask questions of that case. So I could be able to say, show me all the times where there's consumer confusion for this trademark case, or show me all the times where this party argued X. I can now analyze those 954 documents and get good answers from those. That is exploring a collection. I want to find other documents like mine. I want to compare these two documents in a table. I want to find who did what when of 1, 5, 20, 50 documents. I want to be able to summarize these documents. I want to upload a deposition and no prompting necessary, be able to get an analysis of that. I want to upload judicial proceedings, that is video or audio, transcribe it, and then analyze it. How well did we do at that hearing? I want to profile OpenAI or any other party. I want to profile this lawyer and be able to go through David Boies' work, or of this law firm's work, or the other side's law firm's work, or this judge. What's that judge's experience? I want to ask a plain language question of any docket and be able to get that structured data as an analysis. I want to review an NDA, or I want to be able to do a bench memo. We just keep cranking these things out. Next time you attend this webinar, you're probably going to see more, and we just keep cranking these things out every quarter. So option number one is you use all of our things that we keep cranking out. So as you think about it, you have a build versus buy question. How many of these things can you build in ChatGPT? Are you going to do the prompt engineering that my team and I are doing? Because you can see here, this is not a prompt. This is a question, much like you would ask an associate. We take this question, and what you don't see are the literally 35 to 50 prompts on the background that give you this non-hallucinated text and this answer and this here. So if we're doing our jobs correctly, you won't have to be a prompt engineer. You simply ask this question and we give you a good answer. So in your build versus buy analysis, you're not going to want to build this. And you also aren't going to be downloading yesterday's case or yesterday's statute or the secondary materials from the American Bar Association or others. So the build versus buy is pretty clear that you could just use all of our workflows without having to build it yourself. And we keep cranking these things out. With that, TJ, I think this might be a good place to be able to ask or answer questions, or maybe continue our discussion.
Yeah, most definitely. Thank you so much, Damien. That was a great presentation. I'm sure everyone got quite a bit out of that. Let me go ahead and share my screen. We do have a few questions here, but let me make sure that's sharing the right thing here. Yes, so we do have a few questions that I do want to pose to you, Damien, that you may provide a little bit more detail to us on. So one of those questions is, what about docket analysis in state court cases? I know you mentioned we have, I believe, 38 state courts, but maybe you could provide a little bit more detail around that.
Sure. Yeah. So our federal docket analysis is very detailed, as the way I showed you. A lot of these are our federal court cases, and the reason that our federal court cases are quite detailed is because, of course, you have the PACER system that uniformly across all 50 states in the federal side, you have good ways that it's expressed. This is a motion to dismiss, or this is a motion for summary judgment. And so we're able to use that uniformity across all 50 states to be able to very easily be able to say, here's the percentage of motions for summary judgment that are granted in copyright cases, for example. So that uniformity, of course, doesn't exist in the state court side. That is, California expresses things much differently than Florida, than Texas, et cetera. So you can still do similar things in the state court side, and you can still get amazing insights that would have been unimaginable 5 years ago on the state court side, but they just won't be quite as detailed as the magic you can see on the federal court side. But of course, we're doing that work to make the state court side even better too. But I would say that you shouldn't let the perfect be the enemy of the good. We do amazing things on the state court side with Vincent as well.
Perfect. And then another question, how secure and confidential are the prompts? I know this is a really common one. So, and how do you store that information, and do you use it to train your system?
Sure. I'll take it reverse chronologically. We will never train on your data. So number one, we will never train on your data. Number two, our partners will never train on your data. That is OpenAI, Anthropic, Google. They will never train on your data. Number three, how safe is your data? We have an ISO security certification, having a third party that has done an audit saying that we are secure. We also have SOC 2 Type 2 security certification, where another auditor went through and said that we are also secure under SOC 2 Type 2. So number one, we won't train on your data. Number two, our partners will not train on your data. Number three, your data is secure as demonstrated by the audits.
Perfect. Thank you so much for the answer there. We've got one more question, but before we get to that, I know we're getting a little bit short on time. So I just wanted to highlight, all right, so next steps, where do we go from here? in your vLex Fastcase platform. If you click on any of the Vincent AI buttons in the platform, or specifically the card section here, you can start your free trial. So if you haven't already done a 3-day trial, now would be a great time to do that, or just whenever you have the most amount of time to really get into the system and see if it works for you. You can explore a lot of the different workflows that Damien highlighted. So at any point, come on into the platform, start your 3-day trial here, and explore Vincent in a lot greater detail. Now, also, I wanted to provide our contact information here. If you want to get in touch with us, if you have any questions about anything that we're not answering here in the live setting, you can reach out to our support team at helpdesk-us@vlex.com. However, Tim is one of our sales reps, and we can actually provide one-on-one demos. So if you're really considering Vincent and incorporating that and just have questions about any of the content that we covered in today's presentation, please reach out to Tim. You can give him a call at that direct line here on the slide, or send him an email. And then lastly, I just wanted to say, any general vLex Fastcase questions, or any questions at all really, or feedback, I'm a resource to you. So if you have any issues, or you want to learn more about something specifically that you've seen, please shoot me an email. I'm going to connect you with the best person on our team to answer that question, or get you over to, or answer that myself. But with that, I'm going to leave this slide up here. And Damien, if you don't mind answering one last question for us. Someone has asked, do you have access to secondary materials such as ALR, ABA ethics, opinions, etc.?
Yes, we have access to many secondary materials, including ABA materials. We have a lot of ABA sources. And as you think about what is the value of other secondary materials like the ones you've described, ALRs and others? Really, number one, when I litigated, I would look at the table of contents to kind of get a lay of the land as to what has happened. And then once I figure out which of the particular tables of contents matter, I would go to that particular section and I would find cases in my jurisdiction. I would find statutes in my jurisdiction, and then that would be it. So when you think about large language models, and if you can upload a complaint and be able to good analyses, this is better than any treatise. Because if you have a complaint that is a trademark case and a copyright case and a trade secret case, you'd have to go to 3 different treatises. But with the large language model, you upload the PDF and we give individualized analysis for that trademark matter in your jurisdiction, giving you cases from that jurisdiction. So this is not a treatise, this is a metis, that is a customized treatise for being able to customize for your particular facts in your particular jurisdiction. So I would say that the value of secondary materials is drastically reduced because you don't have to go to 3 or 5 different treatises. You upload one PDF and Vincent gives you all of the customized analyses for that PDF.
Well, great timing. We literally just hit the end of the hour. So with that, I just wanted to thank everyone very much for their time today and learning about Vincent AI. Again, if you have any questions or want to learn more or set up a trial, anything, please reach out to us. Thank you all for taking the time. Damien, thank you as always. And we hope to hear from you guys soon.
Thanks, everybody.